70, a resolution of the Miami Planning, Zoning, and Appeals Board recommending approval or denial of an ordinance of the Miami City Commission to amend ordinance number 13114, the zoning ordinance of the City of Miami, Florida, to amend Article 1, Section 1.1, definitions of building function uses, and by amending Article 6, Section 6.1, Table 13, entitled Supplemental Regulations, to provide for a definition of gambling facilities and to require that gambling uses, including but not limited to pari-mutuel gambling, card rooms, and slot machine uses, be approved pursuant to an exception with City Commission approval by a 4-5 vote, providing for zoning in progress.
Good evening again. So I'm here primarily to answer questions and just to illustrate the proposed areas for this to apply. So this basically is a three-part ordinance defining gambling, and it's really deferential to the state regulations. Anything that's a sort of state regulated under existing gambling laws would be applied here. And it's an amendment to the table of allowed uses in D1 and T6O areas, and then the exception process is outlined a bit. So just for your edification, there is the existing T6O and D1 areas, D1 in purple, T6 in red there. This is those same districts in relation to T3, and then here it is with the additional zoning, but keeping the red and the purple. So these are the areas where it would be technically allowed. But again, just getting some of our power back from the state, since the state is currently the only regulating agency. So this is bringing it back to sort of local control. Any questions? Sorry.
So let's open it up to the public and see what we get. Is there anyone in the public who would like to come forward on this? Name and address, you have 2 minutes.
Yes. Good evening, Mr. Chairman, members of the board. My name is Ines Marrero. I'm an attorney with the law firm of Holland & Knight with offices at 701 Brickell Avenue, and I'm here this evening on behalf of West Flagler Associates and the Habenik family. They are the owners of Magic City Casino, and they are really the target of this ordinance because they have a license that has been in the newspapers for a facility on Biscayne Boulevard. And even though there were some articles about this facility about a year ago, when the state issued the license for a high life facility for the location, the city immediately ran and started drafting this ordinance that is before you today. There was a proposal before the City Commission at their last meeting before the summer recess, where they instructed the city management to draft this ordinance. And in that text of that ordinance, there was some language that has carried forward to what's before you this evening that tries to limit our abilities and our vested rights to move forward with our proposal. So what's before you this evening is, first of all, it is flawed because it tries to create a retroactive application for purposes of our rights. If you read the ordinance, there is some language as to putting people on notice, and there is a date that you should pay attention to, July 26, 2018. Today is not July 26, 2018. Today is September. And they're trying to establish the cutoff date for certain entitlements 2 months back. In addition, it is illegal. This is a law that purports to be a general application law. We are trying to regulate gambling in the city of Miami. First of all, gambling already exists in the city of Miami. It existed before Miami 21 was adopted. It existed at Flagler Dog Track, where it's now Magic City Casino, and it existed at Miami High Life. At that time, nobody really cared about gambling in the city of Miami because gambling was deemed to be an entertainment facility, and we received a letter from the city zoning administrator saying that entertainment facility, as the city interpreted, included gambling, and it was allowed in all the T6 designations. Finally, it's a law that only applies to us because there is no other pending gambling facility. If the city adopts this ordinance, the only people that will be coming to ask for this approval will be my client. In the past, and the city has amended the code many times as a reaction to uses in the city. For example, I represent a lot of self-storage facilities, and I recall the city amending the code because there was a proliferation of them because they were not well designed. And there was time to work with staff to see how we could, make sure that the industry's issues were addressed. And finally, it was adopted and it applied to all the self-storage facilities. That's not the case here. We don't know what the illegal effect, what the effects of gambling are, because it's been happening for all these years, and there's no complaints. Nobody has raised an issue. There's been opportunities to amend the code, and nothing happened. This is totally reactive to the fear of this one facility.
Thank you.
I have two more points, and I will let the other people speak if I may. One is that there's nobody really here. The complaints in the media about this issue have come from the Downtown Development Authority. The proposed site is not in the DDA. And the other person that you will hear from tonight is the representatives of a very politically powerful property owner in the city of Miami who has car dealerships on Biscayne Boulevard.
Thank you.
Thank you.
Excuse me, I want to hear that, and then I want to make a disclosure because I'm sorry I couldn't.
So go ahead and make your disclosure.
Okay. I want to disclose that I organized a community meeting. The owner of Magic City Casino was there, and I conducted the meeting. I believe that, I don't know, your opinion is if I was totally unbiased during the meeting, or I was leaning towards one way or the other. I have to say that at this time, I have heard everything, including the hearing at the City Commission when this legislation was proposed. And I have an opinion already, which, unless there is something really very new, is not going to change. So I don't need to recuse myself because I don't have any personal, financial, or any other kind of interest. Just want to say that I don't find this legislation unreasonable because obviously gaming in a residential neighborhood would bring a big change to the neighborhood. And that should be, it's not unreasonable to ask for a special majority and public hearings. But I am not going to participate in the vote because I believe that probably it would be interpreted as like I heard opinions that form my own opinion. Overwhelmed opinion in the neighborhood was against. But I was surprised that people wrote to me supporting the casino, so I'd rather don't participate in the vote.
Madam Attorney, are you comfortable with that disclosure and outcome?
Yes, so you're recusing yourself pursuant to your interest in this. Okay. Okay.
And do we still have quorum? 3, 4, 5. Yes, we're good.
Yes, we still have quorum.
Yes, ma'am.
Hi, Sue Nelson, 1900 North Bayshore Drive, Miami 33132. I attended that community meeting, and I can tell you the temperature in the room was hot. This is a neighborhood, I'm sure you've all gone up Biscayne Boulevard between 29th and 31st Street. It has become so dense, and there is traffic issues, there's development that it's just out of control. I am president of my tower association in a condominium. I can tell you people have come up to me and they are shocked. They are shocked to learn that the casino is going to go in our neighborhood. I've talked to even the police department, and they are telling me the repercussions of this kind of establishment that comes into a neighborhood. And this is an established neighborhood, and I defy all of you. You live in Miami. You can imagine a casino, even though they are telling me it's not a casino, there's gambling, period, that would come into your neighborhood, and the kind of people that would come to this facility and partake, whether it's to gamble, whether it's to have a beverage or whatever. I'm definitely opposed to this. The 4/5 vote, I don't even think is strong enough. I think it should be an unanimous vote by the commission in order to get this, anything like this in anyone's neighborhood. So please do what you think is best, but to me this gambling should not even be in any residential neighborhood. Thank you.
Thank you.
Good evening. My name is Manny Priegues, and I live at 4000 Malaga Avenue, Miami, Florida 33133. I am also here on behalf of the Havoc family and the Magic City Casino. And I wanted to impress on some of the points that my colleague Inez made a few minutes ago, and just go into a little bit more detail. I think that it's really, really important that you keep in mind and bear in mind that in 2012, we sought an opinion from the City of Miami referenced the definition of entertainment facility. It's not an adult facility. Entertainment facility, and whether that included high life fronton, whether it included gambling in general, etc. And that opinion came back in the positive. It was considered by them as included in that definition. So that was back in 2012. So at that point, the city has to know that something is going on, or that somebody is researching this for a purpose, particularly if it's coming from representatives of the Magic City Casino. The same thing occurred earlier this year in 2018, where I myself extended a request of the zoning administrator for 19 different locations that were also trying to make sure that they were zoned according to entertainment facility, and that would include, and it was consistent with the earlier opinion that we had obtained from the previous zoning director in 2012. And we got the same exact result. This was in January of 2018. Okay? Now, let's be very honest with ourselves. These things, these important decisions, and these zoning verification letters are not done in a vacuum. Okay? The zoning administrator doesn't, go into a closet and figure out for himself. These things are vetted amongst many different professionals in the city of Miami. And this, in fact, was. And the exact same result came back. It wasn't only until after we obtained our permit from the state of Florida, because of the zoning verification letters, because of these letters, that an article was produced by the Miami Herald that got certain folks in the community very riled up and very engaged. The aforementioned
in conclusion.
And so I just want to make sure that you feel the fact that this is being directed at this one company that did everything correctly up until the point that they were able to obtain that permit from the state of Florida. And what's going on right now is nothing less than the city of Miami pulling the rug from under them after they went up by doing the right thing.
Thank you.
Thank you very much.
Yes, sir.
Good evening. Peter Ehrlich, 395 Northeast 59th Street. I'm speaking on PZAB number 7, this item. I support the comments from Sue Nelson, who spoke earlier, and I also support the recommendation from the Planning Department that you approve the proposed legislation. Thank you very much.
Thank you. Anyone else?
Very briefly, I think it's important. Steve Helfman, 2525 Ponce de Leon Boulevard. I think it's important that we look at that map where this use can occur. This is not targeted to any particular person. This use can occur throughout the city of Miami. You can see that red corridor. All this ordinance does is say that if you want to have this use, if you want a gambling use, you have to have a hearing. There's nothing that is really exceptional about that. You have hearings every single day for very minor things. And so the fact that the City Commission is suggesting that they would like to have a hearing before a gambling establishment is put in a neighborhood is certainly good policy. It's good for the quality of life in this community, and it'll give everybody a chance to have their day. And if the use that they want is a good use, then they'll get it. And the community will support them, and the commission will support them. And if not, they won't. Thank you.
Thank you.
Izzy Havenick, 401 Northwest 38th Court, Miami, Florida, 33126. My family has owned and operated the Magic City Casino, formerly Flagler Dog Track, since 1952. We have never done anything in this city that was not permitted in the city, was a secret. Everything we've ever done has been known. This has been a 6-year process that everybody who's complaining has known about, everybody in the city has known about. I'm going to set the record straight. This is not a gambling facility. It is a high-life fronton and has the potential to become a poker room also. Neither of which are considered gambling because neither is a game of chance, both are games of skill. I have voluntarily agreed and offered to Commissioner Russell and to the entire commission that we would not put in slot machines. I was told I would be included in the drafting of this language. I was not. This is clearly targeting my family and no one else. If there was such a big problem with gambling, where were these men 10 years ago when Genting bought the Omni? Other than selling it to them, they were nowhere to be found. If these people really wanted to end gambling, they would have done it 10 years ago for Genting. They would have done it now, and they would have made this so that this was language that actually covered everything, not just our project. And that's it. I mean, the facts are this is poker and highlight only and nothing more. Thank you very much.
Thank you. Anyone else? Anyone else? Seeing none, bring it back to the board.
A couple questions. Okay, there's 3 parts. Jeremy, if you could. One, the dates of the zoning verification letters.
Yes.
Can you just repeat those?
Can I repeat them?
There were 2 or there was 1?
So I don't have the text in front of me. Let me...
Or anyone. It really doesn't matter.
No, there are no dates listed in the ordinance.
No, not the ordinance.
Sorry.
Say, were there not zoning verification letters? Did I?
I know of the first one. I'm not. Yeah.
Mr. Chair, can I ask anyone who can answer? Okay.
There were
Sorry, I misunderstood the question.
a letter from Barnaby Min in 2012. I believe it was June of 2012. And then in January of this year, we got 19 letters from the zoning department. Not 1, not 2, 19, saying that we were allowed to do this.
Thank you. Okay. So under the ordinance, you listed that there were 3 substantial parts to the ordinance. 1 was about gambling definition.
A definition of gambling facilities or other facilities regulated by chapters 550 and 551 and section 849 of Florida statutes.
Okay. What is the current definition of gambling in the city of Miami?
There isn't specifically in
But
terms
it's
of zoning.
governed by the state, then? It's a
Correct.
state definition.
Yes.
Okay. Tangentially to Mr. Havenick's comment about highlight and poker, it is my understanding, and this I've now heard it from someone, I always understood that poker was not a game of chance, that it was a game of skill. and that things like slot machines, or what we have commonly throughout the city illegally, maquinitas, are games of chance. You have no idea, right? And that highlight additionally was a sport. There's wagering on the sport, but that it's a game of skill. So now what you are proposing to define gambling as in the city of Miami, would that be then folding highlight and poker into that?
Because we defer to the state rule, and those are regulated by the state.
Regulated?
Yes. So they fall under that, they fall under chapters, I'm not sure which of the three sections of the state code highlight and poker fall under directly. Mm-hmm. If it's 550, 551, or 849. I would have to do some additional research on which one of those it is, but it falls under that.
Okay. More, yes, on that
specific question.
Specific.
Card rooms fall under 849, the Florida statutes. And that chapter also requires, by the way, that before any license for a card room be issued by the state, there must be a vote of the city commission. That same requirement is not repeated in our code, in the Miami code, but it's already required in the state statute,
right.
Which is to say, this is, the concerns about this affecting businesses, existing businesses, is much ado about nothing, because state law already requires that the commission vote.
Right. Our commission in the city of Miami must vote as to whether you can be granted a card room.
Correct.
But the highlight fronton,
correct.
No. Or yes?
I'm not aware of a vote requirement, but
right.
the card room requirement, yes.
Okay. Part two, the existing, or at least based on these zoning verification letters from both two different administrations, allowed for the highlight fronton and a card room, and this falls under the term parimutuel. Does that also include off-track betting? Okay. And so what now the city is asking for is to say that regarding D1 and T60? What's going to change?
So what primarily is changing is this is separated from more other entertainment uses. That's why we're creating this separate definition.
I understand, because previously, or as it exists now, these types of uses would fall under entertainment.
The zoning interpretation letters said they were just typical entertainment uses. The first one, if I'm not mistaken, the first was a zoning interpretation in 2012. Is that correct? And then the letters were verification letters?
The first one was, I think, yes. We may or may not agree.
Yeah.
Everyone. But I'm going to take those as generally zoning letters that tell a developer what they can and cannot do. Something to rely on. That may be litigated in the future, but to me, from where I'm sitting right now, hearing that, I mean, it sounds like I would be basing my opinions on those letters. So part three, what then, I don't understand, so what's part three then? You said that it was a three-part changes that you were seeking, or further definition.
So it's changing the definition.
Right.
Changing it's contained within the table.
Yeah.
Changing where they're specifically allowed, and then the process for that allowance.
Right. And the process, talk about the process now versus the process later, or if approved. Just further.
So this is by exception, which goes to commission.
Currently.
No, currently entertainment uses are allowed by right.
Right. Okay. So you guys would like to turn this into an exception process?
That
is what you are asking
yes.
for?
Yes.
Classic exception. Go to PZAB, two readings.
Correct.
So my point, where I was going to go with this is I don't see anything unreasonable about what you're asking for. That's not the issue, though. The issue here is like, this is the city, in my opinion, at its worst. Because you have great public policy, but you have this reliance. You have a very narrow use. You have no games of chance, as I understand it, as they were explained, unless someone has a different definition. I think we could even look at Biscayne Boulevard as the entertainment uses additional types of entertainment uses are coming to the actual boulevard itself, maybe further up in different ways, in scale to these areas. So when I say the city at its worst, is that it's hard for me to put myself in that position and find that it is appropriate. I mean, sure, just like any applicant can ask, the city can ask, but I think it's too late. I think the ship has sailed. It's an extremely valuable lesson, but I think it puts the city in a strange place, and it looks untoward. And for all the great arguments and public policy reasons, you could say there shouldn't be a high life fronton and poker room, which, frankly, with all the other problems the city has, would be the least of our problems. I think when you talk about people that would go to something like this, I certainly, just my opinion, see it as more of an entertainment type of thing. I would support it, the public policy. I think it's great policy. I could not support it in this instance because it doesn't seem right at all. That's all I have to say.
So let me ask a question. Why are you here? What has the city said you can't do something? Or are you worried that they're about to say something that you can't do something?
The city is asking you to pass or to bless a resolution that they would like to pass to retroactively take away the rights that they've given me.
So you're pursuing your project.
We have been granted the permit by the state of Florida, and we are going in for permits and all of that stuff to build the project.
You haven't been told no. You're just
if
worried.
this passes,
then you're in trouble. But right now, you haven't been told by the city to stop work or stop thinking about this.
Well, I think it pretty much says in there that I'm put on notice.
Okay. And so why is this retroactive? Why can't it just not be retroactive?
Because we're the only ones who can do this.
No, I'm asking the city. Why retroactive it?
Why retroactive to July 2018?
And not just start out now, like most legislation comes before us. And
I mean, I think because this needs to apply to the most recent, the only instance where the state sort of went beyond local ordinances. This is basically a preemption from the state.
Except no ordinance currently exists. I mean, that is factually the case. I mean, the questions have been asked, you guys have even said nothing exists, and we want to now put it into place, even though these guys have been granted their right, given this zoning verification. So based on the framework that currently exists, they have what they need to move forward. And now you're saying, wait, but now there's this new thing for you to move forward.
So if we were to indefinitely continue this item, they could go and do their project. Because this ordinance couldn't get past this board.
I mean, it wouldn't get past the recommending board. Yeah, I believe that is the
We could
case.
install it right here and they could go on and build.
But this is an exception.
Sorry? No, this is not an exception.
Right.
This is a text amendment.
Text
to Miami
amendment.
That has to pass through this board. You can't jump over us because you don't like us.
Correct.
So we can stall it right here and let them
Yeah,
build.
I mean, my understanding is a recommendation up or down can continue to the board. I'm not exactly sure on the procedure and would defer to the attorney
No,
if it
I'm
was
just kind of saying,
indefinite.
because to me, I'd be inclined to approve it if it didn't have the back date.
The retroactive date.
Yeah, because I think it's a reasonable thing to say, let's go a little extra step and talk to the community when these kind of things come in.
How did you arrive at the July 26th date?
That's the date when the state preempted local authority.
But no, it preempts local authority if local authority hasn't exerted itself or created a framework to preempt. That's the part I'm not hearing.
Mr. Collins, go ahead.
I'd like to hear what he has to say, just about the date. No, otherwise,
That date is the date that the city commission passed a resolution instructing the administration to bring forward this proposed ordinance. It's from that date forward that they're saying anybody who is pursuing a gambling facility needs to know that as of that date, they go forward at their own risk because the rules may change. And so that's what that date is. The other thing is, you obviously know this stuff very well because, well, you certainly sound like you do. So, but what you didn't mention about those letters is that those letters have a caveat at the end of all of them that says that this zoning verification letter is the law today when they were issued. And they specifically say that the city code and city zoning code may change and you proceed at your own risk. So the idea that somehow they have these letters which allow them to build this facility is fictitious. They don't have such letters. They have a letter which says, this letter is good for today, and if the city changes the rules. But I think that's important because you clearly are relying upon the letters which you mentioned, and I think it's important that you
I think we got it. We've given you some leeway. Mr. Collins, does that conclude your comments? Mr. Dominguez, do you have something?
I have one more question. Just to go back to a comment you had, you said that the highlight and the poker is not gambling. Were you stating that it's not considered gambling under the Florida requirements? The state of Florida statutes that were referenced here?
By definition, those are not considered games of chance, they're considered games of skill.
Okay. So if you meet that definition that you're not a gambling facility and their code requirement references the state statutes, why would you fall into this category?
Because it specifically references the chapter that pertains to parimutuel wagering, which is chapter 550. And real quick, the letters were not for us, they were for the state, and the state issued the permit in reliance on the zoning letters from the city.
Also, just to be clear though, gambling and games of chance are not necessarily related. You can gamble on a skill.
Right, I understand.
Yeah.
All right, I have no more questions.
I have a question. As a businessman, how much have you invested thus far in this particular journey that you're on?
Well, just over $1 million so far.
Right. So, I mean, I agree with him. From a fairness standpoint, for the city to come in and change the rules after the game's already begun doesn't seem very fair to me, especially when somebody throws down that kind of cash and that kind of money. And I think it sends a bad message to any businessman that does business in the city of Miami where the rules could change in the middle of the game. So I'm inclined to, I don't have a problem with your I feel like the city's changing the rules as it goes along. I think the fact that it's retroactive is a knee-jerk reaction aimed at the gentleman's venture. I don't see a reason why it would have to be retroactive.
So you said you got some letters this year.
Yes.
When were this year when? Like January, February, March?
January.
I mean, so I know it has this asterisk on the bottom, but January is not that long go, and in development terms and getting financing, that's, to me, a pretty current letter that I would rely on to get my financing, whatever else I need. It's not like, if you said if your case was predicated on a letter you got 5 years ago, yeah, maybe I call it a push and I'll go with the city, but you have current letters in my mind. All right,
You want to see the letters?
No, I mean, you're representing.
To me, the only thing that I understand, I kind of see the rock in the hard place here, but at the same time, there's no one that, in my opinion, they're not denying anybody. This can still go to commission and still can perfectly pass. And it's not, in my opinion, it's a citywide ordinance. I know everyone's kind of pigeonholing and saying that it's because of this one particular project, and it may very well be that they're the only ones applying for it at this point. But to me, this is a citywide ordinance that goes to everywhere, and it applies to everyone. So I understand the concern. I mean, the July, I agree if it would have been just a retroactive to apply to them, I agree that shouldn't be the case. But if there's a reason that it's July 28th, which is because that's when the city commission stated that that's when they wanted to start moving forward and putting everybody on notice, I think that is a little bit different than, we just put it back because, they got they're about to get an approval, or there was an approval, or whatever.
Except that's exactly why they did it. I was there.
Well, I wasn't there.
No, I'm just saying, but
I try not to
everybody's making.
If the article doesn't come out of the Herald, we don't even have this conversation.
That's correct. And there's no asterisk, by the way, in this letter.
That's
just the way
I've gone my whole life. My dad. It's not gambling. It's entertainment. Highlight's been here forever. Magic City Casino's been here. Gambling's here. I mean, whether you frame it, whether it's a game of chance or not.
All right.
It's not about highlight.
Sir, you've recused yourself. Yeah. So, unfortunately,
it is about highlight. It is about poker, and that's exactly what I told you in the meeting. If you wanted to make it about gambling, make it about everybody. Make it so nobody else could open. We're happy to sit here and work with everybody. But we played
guys. Hold on. Let's go through the chair. Mr. Dominguez, are you done with your comments?
My final statement would be that if it didn't seem as they were being targeted, I could understand the city's point of view. But in this particular case, I do believe Commissioner Russell, the DDA, Norman Brayman, they are targeting Magic City Casino. If not, they would have come up with this resolution years ago. And I just don't see how right now, right after the article came out in the Herald, all of a sudden, we're here discussing this today. So I think it's unfair to somebody who's obviously invested a lot of money.
I just want to be clear that I'm not basing.
Sir, Mr. Gersten, you've had your opportunity.
This is my thought.
Yeah.
If the gentleman spent the amount of money he spent, and he's been receiving letters saying it's okay, by definition, I just don't see how in the middle of the ballgame the city can just say, hey, look, no, well, maybe proceed at your own risk. I don't think it's fair, and I don't think, whether it's gambling or any other type of business, I don't think it's fair. So just want to put that on the record.
So I wish the city had, when the storage facilities are coming before us, you would have said, we can make this retroactive from the previous year and stop what we got. Because I remember being at these meetings and you said, or the staff said, we can't go back to the other units that have already gotten through the door. So I think you're cherry picking some of your retroactivity. So I don't know, Mr. Dominguez, if you want to proffer a motion, or Mr. Collins, go ahead.
Just one question. So you've already submitted your building permits. You're in the middle of permitting. Is that correct?
We have started going in and applying for some permits, yes, sir.
Okay. So if we were to approve this with a removal of the retroactive date, and that it just gets adopted whenever it gets through the second reading at City Commission, and if they've already started that permitting process, are they kind of grandfathered in because they would have already applied?
I believe the only way they have any grandfathered rights is if they have approved rights. And so that can be either an approved waiver, there's a sort of a threshold, an approved building permit.
Is that administrative or is that in code?
And that's not necessarily for the use. That's for the structure, for zoning.
So I'm just brainstorming a timeline. If we move this, voted to approve this, removing the retroactive date, are they in a race to get their permit before this gets adopted, or are they in a safe position because they would have already started permitting?
It would depend on, I believe it would depend on what types of permits they need, when they applied, etc. So it's difficult to answer that question because we don't know exactly what permits they need, what they applied for, what they haven't applied for, and when the actual ordinance would be adopted. It's difficult to
because I remember we had back to the storage discussion, this will take effect when it's adopted, and whatever projects are in the queue, even if they're not permitted, they applied before the ordinance happened and they were fine. So I would think that this is a similar path, but you're not sure which permit would, in a sense, grandfather them into at least the system?
Yeah,
the process?
I'm not sure exactly what permits they need and whether they applied for them, and if not, when they will apply for them, and the timeline of when the actual ordinance would be effective and the natural route of it. So it's difficult to determine that. I don't know if the applicant has any information regarding the permits that they need, etc., and their timeline on it.
Mr. Chair, with your permission, I have a quick follow-up question to Mr. Collins' question for City on the same topic. And I ask this to everyone. Is this threshold in the code, or is it an administrative rule that you guys have on a piece of paper that changes from administration to administration?
Vested rights are by code and by statute, I believe.
I'm sorry, can you repeat that?
So
the question about vesting of rights.
I'm sorry. Yes.
Yeah.
Well, anyone can answer this if there's a basis in law. When these issues have been litigated, do the rights exist based on an administrative ruling or piece of paper that is changed from administration to administration, or is this strictly a code-based threshold? Does everyone understand my question? Do you understand? I'm sorry. If I'm not being, I know I'm not clear often.
You're making sense. It's neither.
Microphone.
Oh, I'm sorry. Steve Helpman again. The issue of whether you have a grandfathered right is not by virtue of the code or any administration or an opinion. It's as a matter of law. Local government can change the rules. I know it sounds unfair, but they can change the rules whenever they like. If somebody has relied upon something and expended a substantial amount of money and obtained permits, which, by the way, according to the city's own computers, no permits have been applied for here. So I don't know what they're talking about. But that said, there's no retroactivity here. There's nothing in this ordinance that says retroactive. It's not retroactive, okay? It will become effective on the day that the city commission passes it. And if they have certain protected rights on that date, they will have them. So if you wanted to change it, you couldn't. In other words, there's no retroactivity in it. The only provision that's in there, it just says people should be on notice that as of this date, we're changing the rules. But the ordinance only becomes effective on the date that it gets passed by the city commission. So there is no retroactivity.
And if the board would like to clarify that language with its decision, then they can do so and put that condition.
Excuse me, if I could.
I mean,
in response to what Mr. Helpman has asserted, if I could, for the record, Ron Book, 18851 Northeast 29th Avenue, Aventura, Florida, on behalf of Magic City. I simply want to clarify something that Mr. Helpman has said incorrectly. Reasonable people can disagree. The city does not have a provision in its code for zoning in progress ordinances. If they had what other cities have, then this would be a permissible act, and you wouldn't hear us arguing about fairness. And to Mr. Helfman's point, he is mistaken. Multiple permits have been applied for, and at least one has been issued in hand, in our possession. So he might have something that tells him something different. We've got an actual physical permit. And I repeat, there is nothing in the city zoning code for a zoning in progress provision.
Do you have that permit here?
We probably can give you a copy. We do.
I'd make.
Go ahead.
Man.
Yes. Let's see what Mr. Gersten has to say. If you're going to go, to a motion,
I'm going to go to a motion.
Let's go.
I would make a motion to approve the city's language, strike the portion dating back to July, and making a finding that the applicant has relied on representations by the city, and the state relied on those representations and has moved forward with their project in reliance upon, and has a right to continue under the code as it existed at the time that they were granted that right by the state, because the city did not have a framework in place.
So there's a motion. Do we have a second?
I was confused by your motion.
Could we do a finding as part of your...
I don't think you can do the finding part.
Huh?
I don't think you can do the finding part where you're making a judgment.
But aren't we, okay, the condition of, or the...
Breaking section 5? Is that what you're doing?
Then I make a motion to deny.
All right, so it's a motion to deny,
Sure.
period.
Yeah.
All right, so let's see if we have a second. So we have a second by Mr. Dominguez.
I'm sorry, before the board takes a vote, just a friendly reminder that a supermajority is required for a favorable recommendation.
How about to deny? If it's denied, does it have to be a supermajority?
Correct, to recommend approval.
Just one quick question before we vote. In the requirement, it says that the city commission would have to approve it by 4/5 vote. Is that common? I always thought it was just majority.
No, there's a number of things that are by supermajority.
At city commission?
Yeah.
Yeah.
All right, so we have a motion and a second to deny. We'll call the roll.
Mr. Gersten?
Yes on denial.
Mr. Dominguez?
I just want to, before I vote, an explanation. If we vote yes to deny, we're denying the city's proposal to pass the ordinance, right?
Correct.
Okay, yes to deny.
Mr. Altavi?
He recused himself.
Mr. Collins?
Yes.
Mr. Milian?
No.
Mr. Parrish?
No.
Mr. Badillo?
Yes.
Mr. Garabaglia?
Yes.
Motion passes by a vote of 5-2.
Thank you. Is there anything else before us tonight? Is there something?
Well, just like about a discussion item for another time.
Okay.
I'd like to raise the salary and insurance issue again this year, considering